live discussion on a landmark judgment delivered just 2 days ago on 26th of September by the Grand Chamber of the European Court of Human Rights in the case of Yalçınkaya versus Turkey. So given numerous violations found by the court, including an Article 6 of the Convention on the Right to Fair Trial, Article 7, no punishment without law, as well as Article 11 on the freedom of assembly, and important findings by the court in reaching these violations, we believe that the Yalçınkaya case carries broad implications, not just for Yalçınkaya applicant himself, but also for the human rights and the rule of law in Turkey. And today we gather with a stellar line of speakers to shed light on this important judgment. And together we will delve into importance, its future implications, as well as what lies ahead. I am Emre Turkut, a postdoctoral researcher and a legal expert on international human rights law. And today I will be serving as the moderator for today's event. And I would like to extend my gratitude to all of you joining us today. Please feel free to use the chat function to type your questions. And towards the end of our discussion, I will direct them to our panel of speakers. Now, to briefly introduce our speakers, we have Professor Johan Vande Lanotte with us. Professor Johan Vande Lanotte is an emeritus professor of constitutional law at the University of Ghent, my alma mater. Professor Vande Lanotte also acted as the initiative taker and coordinator of the Turkey Tribunal, a non-governmental people's tribunal established to address systemic general human rights violations in Turkey. Last but not least, Professor Vande Lanotte also acted as the counsel to Mr. Yalçınkaya, Mr. Yüksel Yalçınkaya, the applicant in the case of Yalçınkaya versus Turkey, during the proceedings before the Grand Chamber of the European Court. Thanks for being with us, Johan.
Thank you. Welcome.
And we also have lawyer Hakan Kaplankaya, who is a former diplomat and a former registered lawyer at the European Court of Human Rights. Thanks again for joining us. Our final speaker is Judge Yavuz Aydin, who is a former judge in Turkey. And these days he's acting as the director of the Justice Rule of Law. This is a non-profit and non-political organization founded in Belgium. So without further ado, I think we should start, and I really want to start with Johan. So as I have briefly mentioned, you have acted as the counsel to Mr. Yalçınkaya in the case. And, given the numerous violations, I think it means a clear victory against Turkish government's claims. So I want to start with you to understand what you make of the judgment. Could you just please provide us with a deeper analysis of the specific violations highlighted in the judgment? So what the Yalçınkaya case is about, and what did the court found? And as the counsel, how happy are you with the judgment?
Thank you, Emre, and welcome for my part also. We are indeed quite satisfied with this judgment. The most important element of satisfaction, sorry, I will adapt a little bit, sorry. The most important element of satisfaction is the fact not only that several violations have been concluded, but the systemic character of the violations. That's also very important.
Okay, thank you, Johan. So we will have Johan with us in a moment. I think I have just briefly summarized what the court found in this particular case. And as we have highlighted, and as well as highlighted by numerous commentators, this judgment has a very huge potential in terms of its potential impact on future cases. But also, as briefly highlighted by Johan, in terms of systematic problems in Turkey. Like just like the Yalçınkaya case is not an isolated case, the court's findings regarding the abuse of terrorism provisions cannot be limited to the use of bylaw, because thousands, hundreds of thousands of people have been convicted on the basis of their alleged use of bylaw. This is based on an unforeseeable and expensive interpretation by the Turkish court. And the same holds true with other criteria that has been used by the Turkish judiciary to charge individuals due to their alleged membership to a terrorist organization. These criteria includes having a bank account in Bank Asya, or being a member of different organizations and associations, and just being having a subscription to daily news papers. And this obviously creates some systemic and general problems, which has been clearly acknowledged by the court in the Yalçınkaya case. So what I want to ask to Yavuz is that, what are the broader implications of this systemic issues? So how does the Yalçınkaya case fit in the broader picture of systemic general human rights problems in Turkey?
Thank you for having me, first of all. Yeah, that's a very important aspect of this decision, to highlight that there is a systemic and widespread problem of human rights issues in Turkey, in terms of especially Article 6 and Article 7. What is more problematic in this sense, I believe, is that with this Article 7 infringement, the European Court of Human Rights, once again, and in the strongest term, reiterated its belief that there is no judicial independence in Turkey. Lack of judicial independence in Turkey has already been just affirmed by many reports by United Nations, European Union, Council of Europe. And in all these reports, the arbitrariness instead of judicial independence, arbitrariness in judiciary has been underlined for many times. And in this decision, with a special focus on Article 7, which is about the most basic, one of the most basic principles of criminal law, which reads as no punishment without law, which is nullum crimen sine lege in Latin. And especially with paragraph 268 of the decision, the court underlined this fact in this way. The court defined the prosecutions and the convictions by the Turkish courts arbitrary, and it openly said arbitrary prosecutions, convictions, or punishments led the court to this end. Together with this Article 7, I think we should also underline another issue which is equally important, which is the breach of Article 18 in the cases of Osman Kavala and Selahattin Demirtas, which is judicial decisions were taken with political motives rather than sole judicial motives. So when we read these two breaches together, Article 18 and Article 7, the European Court of Human Rights, as I said, in the strongest terms, underlined that there is no judicial independence in Turkey as a whole. And now that it said it's in systemic and large-scale breach, we can definitely say that the court says indirectly that this judicial independence is definitely not in place in Turkey. Instead, there is this arbitrariness. So this is really important when we look into the picture in a broader manner, because Turkey is also the only country among the members of the Council of Europe against which there is an infringement procedure for failing to implement the Kavala decision. And most likely, Demirtaş case will follow this. Demirtaş case will most probably be the second infringement procedure issue for Turkey. And let's remember, Turkey is the only country which withdrew from Istanbul Convention overnight with just one signature, which is about fighting the violence against children and women throughout Council of Europe. And last June, the Parliamentary Assembly of Council of Europe adopted a very important resolution, which says Turkey is the only Council of Europe member state which has been condemned for committing crimes within the context of transnational repression through abducting people from other countries and abducting them to Turkey with the accusation, with the pretext of terrorism-related charges. So this sentence really is inserted in the report which is annexed to the resolution. This is a shame for the country, unfortunately. And again, in this direction, UN's Working Group on Arbitrary Detention reaffirmed for at least 8 times that Turkey, the crimes committed by Turkish authorities by abducting people from other countries and by through this mass arrests and detentions, this may amount to crimes against humanity. And Turkey is also the only country within the Council of Europe which is downgraded to the gray list of FATF, which is the Financial Action Task Force. This is also due to the problems in judicial and supervisory mechanisms in Turkey. And last but not the least, Turkey ranked 133rd among 140 countries in the Justice and Rule of Law League of world. When you look at the freedom of expression, which is also a very important part of this judiciary and fundamental rights issues, Freedom House repeatedly said that Turkey is among the countries where there is no freedom at all in terms of fundamental freedoms, I mean. So this last decision, which again emphasizes the breach of Article 7, really fits in this picture. But unfortunately, where this road will lead Turkey is really being a rogue state or a mafia state. So this may be called like the final warning for Turkey to return to rule of law and justice. That's what I can say for now for this question.
Well, thank you, Yavuz. Your thoughts and insights clearly explains how well the Yalçınkaya case is connected to the broader and wider human rights problems in Turkey, not just arbitrary imprisonment and convictions, but also, lack of judicial independence, silencing of political figures and human rights defenders like Demirtaş and Kavala. Now, I want to turn back to Johan again. He was explaining what the court found in the judgment. And yes, one thing we are really curious about how happy he is with the judgment.
Yeah, I hope you hear me now. It's better now?
It is perfect.
Okay, okay. Well, indeed, we were satisfied and quite satisfied with the judgment, not only because the violations, Article 7, 8, first time 7, and also article about association, but the fact that the stress, even in the press release of the court, on the systemic character of these violations is, I think, very important. This is not an individual case. It's a case, and the court itself mentions that there are thousands waiting, and that the Turkish government should do and make structural changes to avoid that still hundreds of thousands are coming. So there is a systemic violation, and that's what we wanted to hear. Actually, we were convinced, and the court clearly emphasized that it's not so often that the court traditionally is very, very, very careful not to make generalizations. The court tries to judge each case on its own. However, here it is clear that they made a general evaluation of the prosecution of political opponents, and more specifically here the people allegedly belonging to the Gülen movement, for terrorism. And then I come to this violation. It means that, and that is also a general comment that I want to give, terrorism is a hard crime with severe punishments. This means that to define terrorism, things must be very clear. There must be an intent. The people have the intent to contribute to terrorism. And we need to see acts of violence, contributing to violence, aiding violent behavior, or whatever. The court clearly says that the use of violence, being a member of a union that was then banned, being a member of an associated that was then banned, do not correspond to that definition of terrorism. Terrorism has to be something specific and not something that you can, by association, say, you or know this person, you're a member of this association, so you're supposed to be a terrorist. That is not possible. That is a clear conclusion, meaning that the 270,000 people allegedly belonging to the Gülen movement who were condemned for membership of terrorism, most of them were condemned in a way that is contrary to the European Convention. Secondly, and that is also not only for Turkey, but important for all countries, police operations, judicial operations, more and more take into account large data sets, digital data sets, which is normal. Our society is more digital, so it's normal that it's used. However, a suspect, if I may say it like that, has the right to be confronted with this data. And he has the right to see if this data has been collected and presented in a correct way. It is important because it's not easy. If I have hundreds of thousands elements in a file, and police people or judiciary take out one or two elements, that is very misleading. It is possible that I said something else somewhere else, it contradicted. And here the court has said, no, you cannot work like this. Everyone who appears for a court has the right to be confronted with the whole data set, at least have a reason why he doesn't get the whole data set. And with the use of bylaw, here it is clear that this data set that the government said is exclusive for the Gülen movement, and we give you an extract, and that is what you have to take into account, is not viable. So that's very clear. And last element, unions and associations, being member of an association, being member of a union that was legal before, cannot be taken in account as a membership of terrorism. That's the element. And as you see, this has a big impact, of course, to the whole situation of the judiciary, which indeed, as Yavuz said, is not directly said that the judiciary is not independent. That is not said directly, but the court said the judiciary has a stereotype way of working. Someone is brought before them. The MIT says he has used bylaw, so conclusion, he's a terrorist. It was a stereotype way of working, and that is condemned by the court, which is indirectly, not directly, but you cannot read it otherwise, as a criticism of the lack of independence and impartiality of the Turkish judiciary.
Well, thank you, Johan. Indeed, as you have clearly explained, the use of bylaw has somewhat become presumption guilt for the bylaw users, which clearly explains, how this evidence, this particular digital evidence, has been used in an unforeseeable and expensive way, which basically violates many fundamental principles of not just the European Convention, but also modern criminal law, like individual legal responsibility. So from that perspective, the case, the Yalçınkaya case, is more about the abuse and over-reliance of terrorism provisions, which also a warning for other countries in the Council of Europe that make use of digital evidence. So I want to turn to Hakan now and talk about the approach of the European Court of Human Rights in relation to Turkey's post-coup cases. Now, we all know that the court has been somewhat uncritical and unresponsive to the right violations in Turkey. Initially declared a number of applications inadmissible and thus limited the access to Strasbourg protection mechanism. And then starting with, you will remember Şahin Alpay and Mehmet Altan case up until to Akgün case in 2020. The court also employed somewhat limited methodology, giving precedence to some matters like reasonable suspicion and sidelining or ignoring important issues. But with the Yalçınkaya judgment, it appears that a new era is starting, which will be probably characterized by the court's more true in-depth scrutiny of post-coup cases. So I want to ask you, what does the Yalçınkaya judgment exemplify or represent in the evolving stance of European Court of Human Rights in relation to Turkey's post-coup cases? So what lies ahead for the court itself?
Thank you, Emre, for having me. And as you succinctly pointed out, the court's first responses to the post-coup cases in Turkey was not satisfying. Initially, they declared the mass dismissal cases, even there were no domestic remedies available in Turkey. The court has not issued any judgment concerning the detention of journalists which are believed to be members of the Gülenist community, Gülenist movement. So it has just sufficed to decide on the detention of the members of the judiciary. But these judgments have concentrated on the procedural guarantees, the tenure securities. So they oversee the reasonable doubt aspect of the problem. By doing so, they evaded to delve into the bylaw problem. Furthermore, the court remained silent on the bylaw application, the use of this application as an evidence, until the Akgün case, which was delivered on 2021. So, even in the bylaw case, Akgün case, the court's approach did not allow for a broader interpretation that could be applied to other individuals. Of course, however, there is a point that you cannot evade when confronting these type of genuine problems. The turning point came with the Yalçınkaya case, where the court addressed the root causes of the severe human rights violations. The bylaw problem is one of, and the major one of these. These problems were systemic and structural, affecting tens of thousands of victims, as clearly pointed out in the judgment. Consequently, the court sent a strong message to the Turkish government to rectify these human rights violations. It's fair to say that there has been a positive shift in the court's approach to Gülen movement-related cases. But this change was necessitated by the sheer volume of applications received daily, which consumed significant resources of the court. Hence, the court opted for a robust judgment. In this judgment, the court also ruled on the application of Article 46 of the Convention. Judge Aydin has correctly stated, which pertains how to achieve just satisfaction in this case. If you allow me, I want to talk about how this judgment should and may be implemented in Turkey.
Well, we can talk about on the implementation process later on, if you allow me, because I want to ask Johan about the reactions. But for a quick briefing note on the implementation process, just like any other case by the European Court of Human Rights, the Yalçınkaya case will also be submitted to the Council of Europe, Council of Ministers. They will then monitor the execution and implementation of this particular judgment. But I mean, Turkey has clear obligations to implement any European Court of Human Rights judgments, because not just because of its international obligations under the European Convention, but also because of the domestic obligations under Turkish constitution. But the initial reactions to this judgment is not from the government is not particularly promising. So the Minister of Justice in Turkey, Yılmaz Tunç, tweeted a very peculiar tweet in which he argued that the European Court of Human Rights overstepped its competence, because he thinks that the court has delved into the evaluation of the biologue evidence. So turning to Johan, and what might be the Turkish government's likely approach to this case? Do you think that they will be willing and inclined to fully implement the judgment?
Yeah, well, no, I don't think so. There will be a lot of pressure needed to make them move. It is clear when the state, an authoritarian state actually, in case has no arguments anymore, it starts about competence, it starts about all complot theories around it, which we also see in the social media. The government here is confronted with a very severe judgment, once again, saying that there is a systematic problem. To cite Shakespeare, it is like they say there is something rotten in the kingdom of Turkey. That's what they actually say. They cannot otherwise react or to say indeed, and we have to change it in a very profound way, or just deny it and then talk about competence and so on. There is no doubt legally, there is no doubt that the court was stating its judgment within its competence. It did not make over the judgment, but it could not otherwise than see that no arguments were given, that it was clear that the people who came before the judge were guilty by principle, by association, without, and the court says, nearly no possibility to contradict it. So I think it will be very hard for the Turkish government to accept it. And as we saw in the past with the Demirtaş, with Kavala, they will try to find all means not to execute. However, I think judgments from the European Court, in the end, and the end can take some time, but in the end, it will have an impact. It takes time, it will take time, but the situation will not always stay as it is. There is each month, each half year there are new elements coming, there are new judgment, and it's more profounder. At a certain moment, I think an answer will be given, and at a certain moment, justice will be done.
Well, thank you, Johan. Indeed, the implementation of ECtHR judgments is a problem, not just for Turkey, but also, for the Council of Europe itself, and as clearly exemplified by the Demirtaş and Kavala cases. Turkey has repeatedly resorted to some sort of legal tactics or quasi-legal tactics in order not to implement these judgments. And overall, at the larger level, the implementation of judgments is also a particular crisis for the Council of Europe. So 46 members of the Council of Europe have already undertaken their obligations, or they're acting in good faith. But when it comes to implementation of the the ECtHR judgments, there seems to be a systematic problem. I think we all should encourage the Council of Europe institutions to resort to some sort of sanctions for countries that are not complying with their obligations under the European Convention.
Emre, can I just add a little element?
Of course.
We have the Council of Europe, of course, and we need to put all the pressure and all the attention to the execution and the Committee of Ministers and work on that very professionally. That's one element. Often, however, we forget the European Union. The European Union has also a convention of human rights and is very interested in guaranteeing human rights, like the rule of law, for instance, in Poland, just to say that. But is doing still have a union, a border union, has a collaboration and free economic trade with Turkey. I think also the European Union must be put before its responsibility, and not only the Council of Europe. If the European Union is serious about human rights and the rule of law, and they say they are, they have to act. They cannot accept after Demirtaş, after Kavala, now this Yalçınkaya case, just to say, oh, that's a pity, and we make a little resolution. And in my opinion, that is not acceptable.
Thank you, Johan. I think we should now turn back to the judgment and its implementation process, both in Turkey as well as within the or in the framework of Council of Europe Committee of Ministers proceedings. So I want to turn to Hakan. From a legal perspective, we have underlined that this case carries huge implications for human rights and rule of law agenda in Turkey. Of course, hundreds of thousands of people have been convicted on the basis of some very well-known criteria, including bylaw, subscription to periodicals, being a member to associations. So what are some of the domestic legal avenues that those who have been impacted could make use of?
Thank you, Emre. In fact, the court states in its judgment, so there is a judgment which relates to systemic problem, but there is two types of measures that Turkey must resort. First are individual measures, which may be reopening of the case for the Yalçınkaya, but the case is beyond that. The court clearly says that in its judgment that I'm citing, in order to avoid it having to establish similar violations in numerous cases in the future, the defects identified in the present judgment need to the extent relevant and possible to be addressed by the Turkish authorities on a larger scale, that is beyond the specific case of the present applicant. So, and the court gave a message to the government, and it says to Turkish government, to draw necessary conclusions from the present judgment in respect of, but not limited to, the cases currently pending before the domestic courts. So the message is clear. The Turkish government should deal with this systemic problem. For the applicant, it's clear in the judgment. It said there is a provision in Turkish Code of Procedure Law, Article 211, paragraph 1, subparagraph F, says, stipulates there is a possibility to request reopening of the case. So the applicant, Yalçınkaya, probably will resort to this avenue. But the problem is that, is there a solution for the victims whose cases are identical to this judgment? Especially when the court acknowledges clearly the existence of a systemic problem. So in Turkey, so the rationale of the paragraph I cited, the Article 211, paragraph 1, subparagraph F, the rationale of this provision may be interpreted just only the applicants, for the applicants. But there's another provision with the same article, subparagraph E. Let me cite it. So it stipulates, it gives an opportunity to demand reopening of the case if new facts or new evidence have been produced in the case. So it's not clear that this provision would be applicable to other people, but the Court of Cassation has decided on a judgment which is very promising. The judgment is Ibrahim and others judgment, which it has been decided on January, I think, of this year, but it has been published on the official gazette. It gives another authority, another meaning, and this decision was adopted by the General Assembly of the Constitutional Court. So in this judgment, the Constitutional Court accepted the rejection of retrial request regarding the application of the result obtained as a result of individual application to those in similar situations, as well as a violation of the right to a reasoned decision. So the people who have affected by the similar problems, which have been subjected to a Constitutional Court judgment, may use this avenue. Of course, this interpretation must be applicable to the judgments of the European Court too. I think there is no problem in that. But the rationale of the provision of the code of this provision, the subparagraph E of the Article 211, is not that, but the Constitutional Court's approach was promising. But we don't know right now whether the domestic courts will accept the retrial requests on this matter or not. So there is no well-established case law on the matter on the domestic courts, but the Constitutional Court's recent judgment is promising on the matter. So we will see. But the court insists. The court says in its judgment, so there will be a reopening of the case for the cases who are ongoing, who are not finalized. So in Turkey, I think the whole doctrine, all academics and the members of the judiciary is of the opinion that the European Court's judgments, the consequences, the findings in these judgments are binding on the courts. So there is no, so the majority says like that. So this judgment, I think should and must be applied by the courts in ongoing cases. But for the cases who have been finalized, who are before the European Court now, there is a question mark, but we will see the implementation. If in Turkey, the domestic courts will accept these retrial, reopening of the case requests, maybe it will be quite relieving for the court. Maybe one day the court may decide to strike out the cases before it, and the court will be inclined to do it. But there is no clear indication, so there is no clear procedural framework, but there is a basis. There's a basis, and the Constitutional Court has already opened it.
Well, thank you so much, Hakan. I mean, we can all agree that this Yalçınkaya case will be quoted in the coming months a lot, and will probably be a reference case for similar cases involving the use of bylaw. So under 46 of the Article 46 of the European Convention, the court in the Yalçınkaya case clearly called on Turkey to take both individual and general measures. As you have explained, individual measures include the reopening of case, and that is clear for the applicant, Yüksel Yalçınkaya himself, but also those who have similar cases. They might have some avenues based on this framework, because of the fact that the Turkish Constitutional Court's decision in the İbrahimEr versus others, the Turkish Constitutional Court speaks of the objective impact of the ECtHR judgments. By way of interpretation, I think they might be provided with the same possibility as well. And in terms of general measures, I want to turn to Yavuz now. As we have underlined, maybe more than enough, the judgment calls on Turkey to take some general measures in order to address systemic problems in Turkey. So what practical steps could be taken to address those issues? A legislative change, for example, or a change in the Turkish judiciary's approach, not just to use of bylaw, but also other criteria, or amnesty law, which has been fiercely discussed in these days. So what general steps that the Yalçınkaya judgments could lead to?
So there may be some avenues, and the European Court of Human Rights, through the end of the decision, between the paragraphs 407 and 418, as far as I remember, the court tried to guide the Turkish government in terms of implementing this decision. I think when I refer to this decision, please understand it in a way to refer to hundreds of thousands of other cases, not only about bylaw, by the way. Bylaw is being criticized by the European Court of Human Rights, not only criticized, it's now out of discussion that it couldn't be taken as an evidence, but now that the government took this as the number one and the strongest evidence, the court said, okay, this is bylaw, it's of no use, and for the other things, for the other matters, as you define as evidence, like as you said, subscribing to a journal, or sending your children to a school, or any other things, membership to a legal association, for all these things, the court said there is this judicial farce, so to say. So as the avenues to implement this decision for all these hundreds of thousands of cases. First of all, what the Turkish courts at all levels, first instance, Court of Appeal and the Constitutional Court, whatever it is, what the Turkish courts should do is, ending these files with acquittals immediately. So this would be the real implementation of this decision. The second avenue may be like amending the law or clarifying the implementation and the elements of the law. I mean, Article 314 of the Criminal Procedure Code or the anti-terror law. This may also be an avenue, but this is also something with political will. And the third avenue, as people discuss, they say amnesty would be an avenue. I don't agree with that. Personally, I beg your pardon and apologies to all those who think that amnesty would be an avenue. I would say the European Court of Human Rights in this decision said that if there is no evidence, there is no crime. When there is no crime, there cannot be punishment. And with Article 7, it underlined this fact. It underlined the fact that Turkish courts punished these people without a crime. When there is no crime, there would not be a punishment. And when there is no crime, there cannot be an amnesty. This is not acceptable in terms of my understanding of justice, first of all. And now that the European Court of Human Rights in the decision showed underlined the fact that Article 46 of the European Convention on Human Rights is clear, that this decision is definite and it's clear it should be implemented. And it referred to Article 90 of Turkish Constitution, which says that when there's this clash between the provisions of domestic law or the understanding of domestic courts of the domestic law, when there's clash between the domestic norms and the international conventions regarding the fundamental rights and freedoms, the fundamental rights and freedom conventions prevail. And in this case, the Court of Human Rights did this for a reason, to close the discussion which might come from Turkish government about the value of this judgment in Turkish domestic law. Now that the approach of the European Court of Human Rights is this, now that the Court of Human Rights sees this as an obligation to abide by this decision, and now that the Court of Human Rights, European Court of Human Rights, says that failure to implement this decision would be failure to implement domestic law. Let's think such an option, such a probability. Maybe years after now, maybe 2 years after now, maybe 5 years, maybe some months later. When somebody takes this case to the European Court of Human Rights again and says that the Turkish government did not implement this decision and that the applicant asked for some compensation for the failure of implementation of this decision, and that the applicant wanted those judges and prosecutors who are in charge of this implementation should be punished. When such cases go to the European Court of Human Rights, maybe years after now, what do you think? Wouldn't the European Court of Human Rights judges think that the current judges and prosecutors in Turkey would be breaching the responsibilities and obligations to abide by this court judgment. I mean clearly that those judges and prosecutors who do not implement this decision might one day face court cases against them. And European Court of Human Rights may find these applications admissible. And the European Court of Human Rights wouldn't say that paying compensation for these people and punishing those judges who didn't abide by this ruling, the European Court of Human Rights wouldn't say that these are against the convention. So the judges should think twice in Turkey, I believe, especially the judges of Constitutional Court and the Court of Cassation, because the first instance judges will be looking at them. And if the Constitutional Court and Court of Cassation fails to implement this judgment, they will be committing crime first, as I explained. And the second aspect is that they will lose their position as an effective remedy, effective domestic remedy. So if they fail to implement this sooner or later, they will have taken a great risk, personally and institutionally. So I think this issue, these aspects should be really underlined in all platforms, at all levels. And now that that's the Committee of Ministers of the Council of Europe to follow the implementation of this systemic and large-scale breach, in all the capitals of Europe, with the NGOs, with human rights defenders, people should underline the responsibility of the European governments, I mean the members of the Council of Europe governments, to do their work, to force the Turkish government to implement this decision. This is their responsibility under Article 46 of the European Convention on Human Rights. Now, this is also a test for the other members of the Council of Europe member states. This is a test for them if they really respect the rulings of the highest human rights court of Europe. Now, this is not only Erdogan government's test. This is a test for all other European governments. So in this regard, I can again commend what the Platform for Independent Judiciary in Turkey, which comprises International Association of Judges, European Association of Judges, MEDEL, Judges for Judges, and European Association of Administrative Judges. So they have been really crying out for this issue to be solved for years. And in Strasbourg last June, they made a statement, a joint statement again, and they also are happy with this decision. I talked to them, and we owe a lot to them as well for their support in this process. And I believe they will be supporting us in following the implementation of this decision through the Committee of Ministers. Sorry for keeping it long, but the issue is long, sorry.
Yeah, it was perfect. Thank you, Yavuz. I think indeed, as you have rightly pointed out, and this will be a response to one of the questions in the chat. So the Yalçınkaya judgment was adopted 2 days ago, and it takes a bit of time to fully submit these cases to the Council of Europe Committee of Ministers. So probably in its first meeting in 3 months, the Council of Europe Committee of Ministers will start supervising the execution of the Yalçınkaya judgment, because it will be a leading case, obviously, which also necessitates, under Article 46 of the Convention, both individual and general measures. You are a bit hesitant in terms of amnesty, but I do agree with you that it should change the judiciary's approach in relation to evidence that have been used in the terrorism convictions. I think these might potentially provide a much far-reaching, much broader solution to this systemic problem. I want to turn to Hakan briefly, if he has a comment about the amnesty law. Obviously, the implementation of any judgment is not just a legal procedure or process, but also political process. So it might lead to some political solutions in the domestic fora, in this case, in Turkey's political landscape. What do you think of these general measures could follow in relation to the Yalçınkaya judgment?
Thank you, Emre. I fully agree with the Judge Yavuz, Judge Aydin. Yes, his concerns are right. But the politicians' mindset are different from us. Maybe they want to adopt the amnesty bill, but the amnesty, the amnesty will drop all effects, all consequences of convictions. It's right. Maybe to some extent it might be a solution. But in Turkey, in many legislations, especially in terms of to access to public services, there would be consequences who will be the amnesty will not solve this problem in these terms. For example, there is so many impediments. There's many provisions in legislation which says that even though those have been has been accorded amnesty, something like that. So there will be consequences. This is first. And if there will be an amnesty and all cases will be dropped, there would not be a compensation. So the judgment relates to Article 7. So the conviction, okay. Yes, the conviction will be dropped, okay. But there is a direct and inherent result to this. So after acquittal, there would be compensation in Turkey. As you rightly mentioned before, the victims may have the option to open actions for compensation according to Article 141 of the Code of Criminal Procedure. So the amnesty would not resolve these problems, but maybe if the amnesty bill will be formulated in an extensive manner, maybe these issues will be dealt again in this bill, and the acquittal will at the same time give opportunity to the person to have the right to good reputation. So in Turkish we say lekelenmeme hakkı. So with amnesty, the victims would not have this opportunity. So the amnesty bill should be formulated not as a real amnesty, but maybe in the rational or in the formulation of this legislation, if there would be some expressions which may be considered or may be interpreted as a pardon, as an apology from the government, it may be acceptable. I'm sure that the court will be inclined to accept this solution. So the court wants to strike out his cases before it. But I fully agree with Judge Aydin and you. Amnesty will not be the correct and right solution for this problem.
Well, thank you, Hakan. Yes, amnesty law or a potential amnesty legislation could not solve all the legal and political problems, but it could be a good start. So let's not ignore that fact. I want to turn to Johan now and ask about the role of wider international community in terms of implementing this particular judgment. You have briefly mentioned that the EU should also play a role. Maybe they could, the institutions, the EU institutions could resort to sanctions. This could be or serve as an incentive for the Turkish government to take into account the judgments of the ECtHR. But what role should the international community, wider international community, play in terms of implementing or giving this judgment full implementation? Because as the coordinator of Turkey Tribunal, you have been for some time advocating for awareness of the systemic human rights violations in Turkey. So I'm really curious about your take on
Yes.
this.
Well, basically, of course, the judgment is one thing, and we're happy with it, but it's not the end of our procedures in this. First of all, you have the formal follow-up with the Committee of Ministers, but you also have the following up in the Council of Europe and the European Union. And what we think is that we will try to do is to make sure that in a professional way, which means that we will broaden the people who are working with us in a professional way to follow up what Turkey is doing inside the country, and that we will have to work towards European Union and the Council of Europe to clearly give evidence what is happening, what is not happening after this judgment. To be clear also, if at a certain moment a judgment, certainly a judgment as severe as this one, is not executed, you can go back to the court and ask the court to make clear that the execution is not done and that it is again a violation. So also the follow-up will be done. The main element is we need to find and look forward to collaborate with other NGOs, other institutions on each level of execution within Turkey, within the Council of Europe, within the European Union, within the court, with the Committee of Ministers, to follow up step by step each time that's happening. I'm sure there will be some reaction. There will not be the reaction that we want in Turkey. That's already clear, but we need to do that in a very professional way. That's what we now, after we got this judgment, will organize the next months, let's say. And that is not something that is not something that happens in one day or in 1 week, but we will organize it in a structural and professional way, so that the judgment will be a bit in a let's say an unusual way, that the judgment will not sleep, but that it will be working not only today as a judgment, but also the next months and the next years as something on which we based our action.
Well, thank you so much. Indeed, so it's up to now the international community to create awareness on the judgment, so we can all contribute to the effective implementation of this judgment. And for those who are not familiar with the procedure, the implementation procedure before the Committee of Ministers, I could briefly underline that the NGOs can also submit communications for the implementation of judgments. This is called Rule 9.2 submissions in the rules of procedure of the Committee of Ministers. So NGOs can actively participate in the implementation and execution process of the judgments, and this is something we can do. And on an individual level, we could also get in touch with those organizations who advocate for full implementation of judgments. One example that comes to my mind is the European Implementation Network, which regularly checks, how the ECtHR judgments are implemented, and they coordinate some activities. So I think we also have some obligations, as civic citizens, to contribute to this process, because at the end of the day, it's a collective process. So we cannot just expect the Turkish courts, Turkish state authorities to give full implementation of the judgment. So every stakeholder has their obligations. I will just check. I will now check some questions from the chat. We have some time, 5 minutes, I think. Yeah. Okay. So Pınar is asking, so if the Turkish courts do not respect this judgment, what should the people who are affected by it can do? So I think we have underlined enough that we can do, we can actively participate in the process. We could do a lot. But in the meantime, let's wait for the Turkish governments, how they would officially react to the judgment. Because I have explained that the judgment was adopted 2 days ago. So again, it takes a bit of time, usually 3 months, for the Committee of Ministers to put the particular judgments in its agenda. So the Yalçınkaya judgment will probably on the agenda of Committee of Ministers in their next meeting in 3 months. Hope they will be, so that the government, the Turkish state authorities, will be willing to give full implementation of the judgment. Again, so the judgment has clear warnings to this over-reliance of terrorism provisions and abuse of them. So it provides a route for the Turkish government as well to take the country back to normality, because since 2016 the country, even though there is no official state of emergency, the country is under extreme circumstances, conditions. So I think this would provide a shortcut for the Turkish government to take the country back to normality as well. Fikret is asking, can the emphasis on systematic nature of violations be linked to Article 18, misuse of power? I don't think so. I could just direct this question to Johan to take, so to get his take on it. But I don't think Article 18 was among the claims in the original.
Not here.
No. Article 18 has not been brought forward, and actually it has a bit another dimension. Abuse of power is abuse of the convention. I'm sorry. So I don't think that was what was happening here. We saw it in some other case. I think in the Demirtas case it was, and in the Kavala case, but here it was not introduced, and it is not so relevant. We wanted to state clear that the acts, even if not proven, of using a telephone, being member of a union, being member of an association, cannot be seen as terrorist acts. Innocent people who has nothing to do with terrorists cannot be considered terrorists. That was what we needed to be stated, and be stated that the people who are accused of that have not the possibility to contradict. Article 18 is different, I think, and has no real link with our the arguments we brought forward to the court.
Thank you, Johan. One final question is coming from Rabia. How will this decision impact individuals who have already served their sentences? Will they be able to request a retrial according to Article 311 of the Turkish Criminal Procedural Law? Hakan, do you want to react to it? You have briefly explained before, but you can just...
Yes, in fact, we have already responded to this question. Yes, there will be option, but there is no clear indication in the legislation, so we are not sure, we are not as certain that the domestic courts will accept or not, but the recent judgment of the Constitutional Court is promising in this aspect. So we advise those who has convictions, whose cases has been finalized, to use this remedy.
Well, they could use this remedy, but it's no guarantee that they will be afforded this opportunity. Yeah, so the Turkish Constitutional Court could perhaps adopt a pilot judgment, and then they can take it from there. So I think it'll be the most, maybe also a potential judgment by the Turkish Court of Cassation. So these two things could be promising for what lies ahead. I don't think there is any further questions. Do you have any final remarks? Yeah, go ahead, please.
A message to me from one of my former colleagues came in. She was also a judge, and yes, the issue she raised is really interesting, because for more than 90% of the judges who were purged and arrested in Turkey after this 2016, July 2016, for most of them, in none of their cases, there's none of these evidences, so-called evidences, and even not having sent their children to a particular school, or not having a bank account at Bank Asya, or not being subscribed to this journal, along with having academic career, or having been having been to abroad and having attended PhD degrees in United States or Europe. These were shown as evidences again, as if these people were a member of a particular group. For these people as well, I believe now that this Article 7 breach is underlined here, even for my colleagues and for many people from Ministry of Foreign Affairs or from the army, where none of these so-called evidences were used by Turkish courts. Now that we have this Article 7 violation in a systemic and large-scale manner, referring to hundreds of thousands of cases, I believe they can also resort to all these remedies, and they can also ask for retrial or acquittal and all other things, because this issue should not be neglected. This systemic and wide-scale breach is the most important aspect of this decision, along with Article 7 breach, I believe. Sorry.
Thank you, Yavuz, for this additional clarification. Do you have any final remarks, Johan, Hakan?
Thank you.
No, I'm fine. Just to say that we will follow up. This judgment is the beginning of something. It's not the end, and it will be important to get support from as many people and also as many independent organizations as possible, because this not only concerns specific victims, but it's a whole system that is in question and important for the European judiciary structure and atmosphere. So we will follow up, and we hope to do it with as much people as possible to do that.
Thank you, Johan. If there is no further final remarks, let's close this session with that good intention that the Yalçınkaya case will just be the beginning. And we are sure that it will be referenced a lot in the coming future, not just in legal circles, but also political circles in Turkey and elsewhere. Thank you to the speakers for being with us. It was an excellent event. And thank you to all audience for joining and being with us.